Okay, let's call this meeting to order. We're a few minutes late, and we have, I suspect we're going to need all of our time today. So I'm going to call to order the meeting of the Independent Ethics Board for the City of Tallahassee. It's Tuesday, April 16th, 4:07 p.m. We're in the chamber, the Commission chamber in City Hall. There are three things we have to get, well, we hope to get done today. One is to complete selection of our board council formally so we can sign a contract. Second is to consider the amendments, and we have a number of them, to our proposed ethics ordinance recommendation to the city. And the third is to approve our annual report to the city, which we are required to submit pursuant to the charter. And that annual report will include, one of the things it will include is a recommendation of the ethics ordinance draft that we adopt, hopefully amended today. So with those three things, Mr. Reed and Mr. Claypool are sitting down at the end here. So to the extent that you have questions when we get to item 2, which is the ethics ordinance, the recommended ethics ordinance and amendments to it, they will be able to answer on the mic. Where we were on selection of board council, at the last meeting, we kind of pooled everybody, and there were 3 names that came up, and you all got additional copies of their resumes. Mr. Claypool, Mr. Currington, Mr. Reed. Those were the 3 names that came up as top choices for numerous board members. So with everyone's concurrence or without objection, I would like to limit our discussion to the 3 of them rather than to the broader pool of applicants that we had. There are 2 ways that we could do this. One is we could just go down the line and everybody state their top choice to get a feel for where we are, or we could take a motion and a second and vote on a particular person. Personally, I'd kind of like to, without it being binding, just go down the row here and get everybody's top choice to see if we are split or if we are in concurrence. Is that, I'm seeing nodding of heads. Okay, well, let's go in kind of in order of seniority, I guess. That puts you up first, Mr. Smith.
Okay.
Oh, I'm sorry. Well, I'm sorry, seniority. It would be Ms. McNeil. I apologize.
No problem.
It's hard for me to think of you as senior.
I know, right? Well, I'm sticking with my original choice, John Reed. I think he's done great work for us, and he was a great advocate when we had a closed session. So that is my choice.
Okay, then we would go to Mr. Smith.
Okay, I'm still in support of Mr. Claypool.
Then who would be next? Mr. Payne.
John Reed for me.
Okay. Then I think Ms. Graywall.
I would also like to put my vote in for Mr. Reed. My understanding is that Mr. Claypool will still be consulting with us, correct?
We can make that decision.
Okay.
Ms. Graham, I skipped you in order there, I think.
I never worry about anything like that. Mr. Reed.
Okay. And Mr. Ray.
Mr. Reed.
Okay, and mine would be Mr. Claypool. That puts us at 5-2. So if somebody wants to make a motion, I would take a motion.
I move that we select Mr. John Reed as counsel for the Independent Ethics Board.
Second.
And this motion and a second for Mr. Reed. All in favor say aye.
Aye.
Opposed say nay. Mr. Reed, congratulations.
Thank you.
That puts us on our draft report. I'm going to skip a little bit here and go straight to the amendments. We are working off of the document that we are amending is the document from our March meeting. If for anybody who has looked at it online, it changed slightly in terms of the line numbers in the most recent version because we had some spacing issues, some left justification. So if when we get to an amendment, if you see that your version of the draft ordinance and the amendment, the line numbers in the amendment don't match, you may be working off of the old version. That's exactly where I was up until a couple of hours ago. So I know it can happen. Are there any comments on the draft ordinance as we discussed it, before we get to the amendments, on the draft ordinance as we discussed in March?
Mr. Chairman, I'm just want to clarify, as we discuss the amendments, and I want to apologize to everyone for not being at the meeting that we had to discuss the ethics, the language we were going to convey to the City Commission. I've had a family emergency that I needed to be out of town to take care of, and I actually came back to town for this meeting, and I'm going back down south tomorrow. So in terms, the only area that I would like to suggest a change would be in the area of corrupt intent. Is now the proper time to talk about that, or would you like to?
We have amendments, I think we have 3 different amendments on that. So what we'll do is when we get to those amendments, we'll have a full discussion, and we'll let not that we don't have a bunch of attorneys up here, but we'll let the 2 attorneys who've probably thought about it the most down at the end here answer any questions you have.
Great. Well, I'll hold my comments until then. Thank you.
Okay. I want to reinforce the public hearing was great. The amendments that we will consider today came from a number of sources. In the summary that's prepared for most of the amendments, it notes at least one source for the amendment, so you can tell whether it came from a public comment or if it was something that staff uncovered as an issue. I do want to thank in terms of the public hearing, the comments were primarily from Citizens for Ethics Reform. You'll see these folks, they've been at every one of our meetings since the board was established. They actually supported this board before it was created. For those of you who don't know the history, there was a work group that the city commissioned to look at ethics, and it came up with a number of recommendations. One on which the work group was split was the creation of an independent board. The city chose not to do that. The Citizens for Ethics Reform was one of the leaders in proposing and getting approved by the voters the charter amendment. So you can literally say they've supported the board in its creation since before we existed. And their recommendations at the public hearing were very specific. They went just through the draft ordinance line by line and made recommendations to us. In many cases, we were able to adopt things or to draft things consistent with their proposals. What I'd like to do today in order to speed the process, if this is okay, I'm going to propose that Mr. Smith move the amendments as a group and Ms. McNeil second that. That would not mean that they are going to vote for every amendment. It would just mean that we would procedurally be able to move quickly from one to the next without having to go through a Robert's Rules kind of process. So if that's okay, I'm seeing Mr. Smith.
That's fine.
Moves all of that we consider all the amendments. Ms. McNeil seconds that. All in favor say aye. 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 Opposed say nay. So now we are on the amendments. And these go primarily in line order. There are a couple places where there's a technical amendment that may jump us around, but pretty much we will go page and line through the draft for anybody who's trying to follow, so we won't be too confusing. What I'm planning to do is if we'll do a voice vote, and if there's no dissent, we'll just show every member as voting yes. If there is any objection on any amendment, and even if we're pretty sure it's only one person, we'll go ahead and take a roll call so that anything that is at all controversial or at all in question, even for a single member, gets a formal recorded vote. And I'm seeing nods on that. When we get done with the amendments, we will have our March document as amended. We will take a motion to adopt the March draft as amended tonight as the final version, and that's what we would then send to the city along with our annual report. So there should not, at that point, need to be any further action by the board. Obviously, there are issues that we will follow up on, either for future recommendations or things that fell out of this that could go into our bylaws or into our procedures that don't have to be in ordinance. So now I think I'm ready to go to the First Amendment. You'll notice these are numbered by the section of the code that they're amending. So the First Amendment is 2-3.001. You'll see in the summary this is primarily a technical amendment that staff identified for consistency of wording. Is there any objection to this amendment? Mr. Reed.
While you're going through the next two, we do have some amendments proposed by Mr. Payne over the weekend, and apparently those were not in the packet, so I was going to just walk along the line.
Right, I think I will. I think I can point. Oh yeah, if you're going to hand them out,
them, but
great,
they don't have them.
great. I will point out when we get to those additional amendments that were not in your packet. We invited members to submit their recommendations, and we drafted those, and given the timing of some of them, they did not get posted. So number one is approved. 2.2-3.002. This is, in terms of covered individuals that would be included for some of the provisions in the ethics code, this adds people who are registered to lobby the city or required to register to lobby the city. So these would be non-city employees. I would point you to somewhere I have the ordinance. I'm going to borrow your copy. The Charter Amendment.
This one?
The problem here is that the Charter Amendment somewhere says that the City Commission shall enact ethics or conflict of interest code with jurisdiction over officers and employees of the City of Tallahassee. It does not include, Charter Amendment does not include within the city's jurisdiction reaching out as an in the ordinance to persons who are not employees or officers of the city. So, Mr. Reed or Mr. Claypool, did I get that right?
Yes, it's section 61 of the city charter explicitly states that the board shall have jurisdiction over the officers and employees of the city of Tallahassee.
So, is there objection to this amendment? And I would say I object.
I object. I object.
Okay, so let's go. Ms. Graham?
I object.
So that's a no. Ms. Graywall?
I object.
No. Ms. McNeil? Object. No. Mr. Payne?
Object.
No. Mr. Ray?
Object.
Mr. Smith?
Object.
And me. Okay, so that one fails. 2-3.003 is an amendment. Well, there's an amendment to this amendment. And this, so let's, the amendment changes from elected appointed officials to public officials because we've added a definition. And that makes that appropriate, so that's kind of technical. And then it fixes the definition of procurement employee, again, I think in primarily a technical way, but the amendment to the amendment is Mr. Payne, I believe, so we would be on 2-3.003A.
Yeah, this was just a technical, it was the way it was originally stated, trying to get.
Oh, is this where you're changing shall mean to means?
No, he's
Is that
who?
Delete.
Oh, I'm sorry, adds who, I'm sorry, adds a who. Oh, okay, so this is a grammatical change.
Yes.
Okay, is there any objection to this grammatical amendment, to
No.
the amendment?
No.
Okay, so
No
that one's
objection.
adopted. Huh? I don't think I heard that objection, if there was. So that puts us on the main amendment, 2-3.003. And Mr. Reed, am I correct in describing this as primarily technical?
Well, the first one, it added the word who, but then you were correct about the shall means, or shall mean was replaced with means to just make it consistent with the other definitions. As far as 3.03.
On the main amendment.
Yeah, on the main amendment, where it is different from the draft ordinance is we removed elected and appointed city officials and replaced that with public officials to be consistent with our other sections. And procurement employee, we included the definition. Previously, we just stated it covered procurement employees, but we didn't define it. Here, we included the definition, and instead of putting it in the definition section, well, it is in the definition section, but we put it under the covered individual specifically.
Okay, so any objection to 3.003?
No.
Seeing none, that one's adopted. That moves us to 3.004, and there is an amendment to this amendment. So the main amendment defines gift rather than relying on a cross-reference to the Florida statute definition of gift, and it picks up language from the State Commission on Ethics from a rule of theirs in terms of what is an indirect gift, something that I understand they struggled with mightily. Mr. Claypool, do you have any comment on the indirect gift part here?
Yes, it was a great struggle. The state law does address indirect gifts, and so the Ethics Commission looked at that both from the perspective of someone who's receiving a gift, a public official who's receiving a gift indirectly from a lobbyist, for example, through a third party, and also, well, let's see, where the gift is provided by somebody other than them, than the gift, but the gift has been paid for by somebody who's prohibited, and that would be considered an indirect gift as well.
Okay. So that's the main amendment. Now, there is an amendment to the amendment, and then there's a subsequent amendment, and they kind of tie. So the amendment to the amendment, this is 3.004A, strikes lines 78 to 94 of the main amendment. Turns pages. I know we're in trouble when Mr. Smith has the desk covered in paper. So this would delete the definition of relative. But then we have another amendment that's tied to this. It would be 2.2-3.009, which should have also just been handed out to you. These both come from Mr. Payne. And this includes a definition of relative a little later on. So Mr. Payne, you want to tell us what you're accomplishing with these amendments?
One of the main problems I had with the, in a later amendment, actually, was that it was a very narrow definition of relative. And it is very different from what you see in Chapter 112, which expands it a great deal. And I think our purpose here is to make things very cut and dried, not just what is a gift, but what is excluded from a gift, what relatives can be excluded. I don't think we need to be penalizing public servants for giving gifts to their grandmother or granddaughter or that kind of thing. So adopting the full text of Chapter 112 in terms of relative, that's what we did there, and separated it from the First Amendment, I think, was included as part of the definition of gift, but Mr. Reed separated it out as a separate amendment or separate definition.
Okay, so we would not have relative defined under gift, would give relative its own definition. So the amendment 3.004A is an amendment to 3.004, and all that does is strike relative from the main amendment. Mr. Reed?
Yeah, if I could, there's actually 3 of the new amendments are somewhat tied together. If 3.004A is adopted, it removes relative as a sub-definition under the definition of gift. If you were to do that, you're going to want to adopt 2-3.009, which puts the definition back in, but now it's a freestanding definition. The purpose of this is previously it would only be attributed to any issues dealing with gift, which is 2-13. We felt that we would give it its own standing definition, so it would apply to any prohibited act that occurs through the code. Now, at this time, there is no reference to relative in the code, but if somewhere down the road we were to do so, we would have the definition freestanding and it would apply. So,
Okay.
And then as far as the other amendment, the 2-13.001, that addresses what Mr. Payne referenced, which was in the gift ordinance as currently the law today, it has a very limited scope on who family members are. It's essentially just the immediate family, and this expands it to where 112 is. The only difference, ours includes domestic partners, which is not in the state statute, but we included that.
Okay, so we'll get to that in a minute. So right now, we're on 2-3.004A, which just strikes line 78 to 94, which we're going to replace later. So is there any objection to the amendment to the amendment?
No.
Okay, that puts us on the main amendment, which is 3.004. Anybody have any questions? This is a lengthy amendment, but again, it's picking up the definition of defining gift rather than having a cross-reference in the statute and picking up that definition from the Ethics Commission rule on indirect gift. Mr. Payne.
I do have I don't really see the need of spelling out the definition of gift when it already exists in statute. I would prefer, rather than basically cluttering up our document, a reference to Chapter 112 to designate the what a gift is. Ms. Meadows-Keefe normally includes in her training what exactly a gift is and the exceptions for relative as well. So my feeling is if a reference to 112 is sufficient for our purposes, that way if statute changes, we don't have to go back and keep correcting things. We're relying on the legislature to handle that part of it.
Okay. I know this issue came up in our public hearing. One of the comments that we heard was that there were people who thought that they would prefer our ethics code to be freestanding, where you didn't have to, you could pick it up, read the ordinance, and know exactly what you had, and you didn't have to reference other documents. I mean, I think that was part of what drove this. I don't remember, Mr. Reed, Mr. Claypool, did we make changes? This definition comes largely from 112, but were there technical changes that were made in it? I don't recall.
As far as any reference to an agency, it was removed, so it was very narrowly drawn to city.
Okay. So we certainly can do this, the statutory cross-reference. And if that's the direction we want to go, then we'll have people draft or get us right drafting-wise here during the meeting. But so you were, well, I don't know where you are.
My feeling is, although I did want to expand the definition of relative, which is part of the definition of gift, if we just use the reference to Chapter 112, we can just basically cut that out again so that we're not having to go back and correct it when the statute changes as well, if it does.
Okay, so you basically would like an amendment that removes line of the main amendment to the amendment, that removes lines 5 to 5 to something, I don't know.
Actually, that's
Removes
the
the first
entire amendment to
Yeah.
the...
Mr. Chair, if I could make a point.
Please.
I completely understand what Mr. Payne is attempting to do. However, I was not at the special meeting, so I'm somewhat limited in understanding what the conversation was during that meeting. But I think it will benefit the city of Tallahassee and those who are operating under the ethics code to have it all in one place. I don't know if you're a lawyer or not, but as a lawyer myself, I have found that documents that refer to the statute can be intimidating to those that are not used to reviewing statutory language. And if we have it all in one place, then anybody that wants to understand what are the requirements, what are the ethical requirements of the city of Tallahassee, can go to one document itself. No disrespect to Mr. Payne, because I do think that there is a cleanness that comes from not having, but in this case, I think that it would be a benefit to have it all spelled out rather than have to go to different sources to find the answer.
Okay. Other comments? Other members?
Mr. Chair, I am willing to defer to the majority here. I just wanted to express
No,
my opinion.
I understand what he's saying, but those are my thoughts on the issue.
Okay, well, in that case, we are on Amendment 3.004 as amended. Does anyone have any objection to this amendment? Any objection to the amendment as amended? Seeing none, it has passed unanimously. If we can, I'd like to go ahead and, because we're talking about it now, jump to the amendment that was in the packet that was just handed out to you, 3.009, which puts the definition of relative in as a freestanding definition. We just took it out of the definition of gift in the previous.
So we would need to restore it.
So now we're putting it back in as freestanding for future-proofing the ordinance. Any objection to any questions about 3.009? Any objection to 3.009? That's good? Okay, that one passes without objection. Now we're back in order. So we're on 3.005. This removes lines 103 to 129. This is technical, and you all remember that we went through a number of drafts of the proposed ordinance. There was a term that was used in some earlier drafts that is no longer used anywhere in the ordinance, and this simply removes a definition of a term that is not used. So I would consider it technical in nature. Is that a fair description, Mr. Reed?
Yeah, the term outside employment would have, there's two sections that are very similar in section 112.313. That's the doing business with an agency and conflicting contractual agreements. We decided to take the two issues and combine them. The term outside employment was a term used in the statute dealing with doing business. We didn't end up using it in, so at first we thought we were going to use it. It's now not referenced in the ordinance, so it's no longer necessary.
Okay, so this amendment basically removes surplusage. Any objection? Without objection, 3.005 passes. If I'm going too fast, throw something at me or get my attention in a kinder way. 3.006. This is a technical amendment. There is again, there are a couple extra words in here. I think we strike that we're removing the words "and include" that were kind of surplusage from a prior draft. It used to say, I think, resource means and includes information. Now we're just saying resource means information. Any objection to 3.006? Without objection, that one passes unanimously. 3.007 is a change in the definition of special privilege. Mr. Reed, you want to walk us through this one?
This was an issue that was raised. This was raised at the workshop by the members of the coalition. We, I think, originally just had similarly situated members. They wanted to stress that we make it clear that similarly situated members of the general public. So that's the language that was added.
Okay. Any questions, comments on this? And I thought at the workshop this was a great suggestion because we previously had, if you were similarly situated persons, which would mean other city commissioners in other cities, that didn't seem to be the right standard. It ought to be similarly situated members of the general public, so that it was a broader class of people that you were being measured against. So, great catch. Any objection to 3.007? Seeing none, that one passes unanimously. 3.008. This goes into the section on the loyalty oath and adds that a violation of any provision of the oath constitutes an ethics violation. And I would ask for comment or explanation from Mr. Reed or Mr. Claypool.
This was, the members of the coalition asked that the loyalty oath, which is simply required under state statute, be enforceable, and any violation of that being constitute a violation of the ethics code. The only issue I raised with that is it could be seen as overly vague, and there could be a challenge that it's hard to determine exactly how somebody would violate that. Essentially, I think ties back to all of the prohibited acts that are in the subsequent sections. But this is simply an oath that's required by statute. But that was essentially the goal that was put forward.
Okay, so this would mean that if you violated the ethics code, so if you didn't, for instance, have a constant appearance of propriety, that would become an ethics violation, would come before this board. Or if you did not live up to the highest standards of professionalism, that would be an ethics violation, it would come before this board, or however we would define it. So we were worried about a void for vagueness in terms of enforcement. So that said, is there objection? I would say I would object to this one.
I object as well.
Okay, so let's go down the row here. You can just say yes or no. Ms. Graham?
Object.
No. Ms. Graywall?
I object.
Ms. McNeil? Mr. Payne?
Object.
Mr. Ray?
Object.
Mr. Smith?
I do not object.
Okay, you're okay. And me, I would say no. So that's a 6-1. So that one fails. That moves us to...
Mr. Chair, I would just like to say the reason for my objection is I believe that the intent of the rest of the ethics code is to put meat on the language that's contained in this oath. And so the point of us revising the ethics code is to make sure that we're clear what's required to meet the oath. So I think it's superfluous to what we're already doing.
Okay. Thank you. And Mr. Smith, any comments, or just you're good? Okay. That moves us to 2-4.001. And correct me if I'm wrong, guys, but I think this changes elected and appointed or appointed officials to public officials, and it removes surplusage that says that the city should take steps to continue the city's current practice of insuring. It just says insure. So rather than commenting in an ordinance on past actions, it just is forward-looking rather than backward-looking.
Can I make a grammatical comment? Should I say
Please,
steps
Mr.
to
Ray.
ensure?
Excuse me?
Should I say take all steps to ensure?
Take all, you want to strike the word practice?
No. I just want to put the word to. Steps to ensure, right?
Oh, to insure.
There was an amendment to that to
Oh,
There was?
insert to.
Is that yours?
No, I'm not sure if that was.
Okay, there was a substitute that was just
Yeah, it's
filed.
Okay.
okay, who's that?
It's 2F.
Okay, we have a substitute amendment to this amendment on line 6. Before the word insurer, add the word to, T-O, underlined or underscore. So is there any objection to the amendment to the amendment? Seeing none, that one passes. Now we're back on the main amendment. Any objection, any questions on the main amendment? Any objection to the main amendment?
Hang on, which one are we on now? Is it 24002S?
No, we're on 2-4.001 still.
There's a lot of paper up here.
Yeah.
Mr. Chair.
Yes.
Mr. Chairman, if I may, because I think
Yeah, okay.
we actually have two amendments that look very similar, and I think that may be part of the issue. And the substitute amendment that was just handed out prior to the meeting was drafted to 2-4.002, not to 2-4.001. I think you could meet the same goal by just taking that amendment as a oral amendment at the table. So the word "to," we got a little too ambitious with the cross-out feature, so that word "to" needs to go back in.
Okay, so on, and we're going to look at this same language, but this is largely technical. So regardless, we're going to make these technical changes in paren A. So there's 2-4.001. Any objection? Seeing none, that passes. Now, we are still on the same language, but another amendment that does more stuff. So in terms of 2-4.002, we have an amendment to the amendment on line 6, add the word "to," T-O, underscored. Any objection to the amendment to the amendment? Seeing none, that passes.
I'm sorry. You're on 2-002?
2-4.002, we just amended it to insert your word "to,"
Yeah.
T-O. Now we're on the main amendment.
Yes, I do object to that.
But, so we've perfected the main amendment. Now we've got a substitute amendment. So the process would be, well, let's first, Mr. Reed, describe to us the main amendment, please. 2-4.002.
It's identical to 4.001 with the exception that there's language added at the end. And this was also put forward, I think, by the members of the coalition that would, the Ethics Board should establish a section in the employment application with the city that would require applicants for a job with the city to divulge ethical misconduct or malfeasance within prior employer.
Okay. Now, so that's what the main amendment does. Now we're going to come off of the main amendment and go to the substitute amendment. If we adopt the substitute, the main amendment is dead. If we fail to adopt the substitute, we will be back on the main amendment. Everybody with me procedurally? Okay, so on the substitute, this is 2-4.002S. And Mr. Payne, this is yours, I think?
Well, this amendment, was my understanding, it was just to insert the "to," word "to."
Oh, okay. So this was getting the 2 back in.
Yes.
So we've effectively done that.
Yeah, my objection is to the main amendment.
Okay, so you're going to withdraw 4.002S
Well,
because we've already fixed the 2 language.
okay, if that is already fixed, then that's fine.
And then, because we will incorporate, if we adopt multiple amendments to one section, we will incorporate all of those amendments because there shouldn't be a conflict among them. Now, we're back on the main amendment, 2-4.002. Mr. Payne.
Yes. My objection here is the substantive language here to insert a line in employment applications to divulge ethical misconduct or malfeasance. When I read this reminded me of what was something called Ban the Box a couple of years ago, where we removed the indication that you've been convicted of a felony, which essentially means that if you're applying for a job there, that application will be put in the no stack immediately, which effectively is saying to the world, there is no rehabilitation. Once you've screwed up once, it's it. This is the same kind of language here. It also made me think of the city-sponsored program called Tempo, which is a very good program that seeks out young people who have left school and run into trouble with the law. They seek out these people with mentoring, job training, apprenticeships, and things like that to place them in jobs and make them a valuable member of society. What this language says to me is that for these people, yes, congratulations, you've graduated from the Tempo program, but don't count on getting a job with the city. And that's what I strongly object to there.
Okay. Other comments?
I feel the same way. I also doesn't go in depth. How long does this apply? I just think that it cuts out too many potential good employees. Ethical misconduct could be a $15 gift from a job you had 20 years ago. And then to be held to that years later, months later, I just think it's unfair for the employment process.
Other comments from board members? I'll chime in here. The other thing that I would add in terms of a potential problem is I think that the board, we make recommendations concerning ethical matters outside the ordinance to the city, and I think we can clearly make all kinds of recommendations about ethical hiring practices, ethical employment practices, ethical procurement practices. This is the kind of thing where we can make recommendations to the city to put it in an ordinance. To me, kind of has the ordinance assigning us what to do and limiting what we can do in that area. And I would rather take this kind of action on our own initiative in terms of making recommendations to the city rather than have it be something where the ordinance tells us we must take an action. So I think we have at least several objections, so I'm going to take a roll call vote on this. Ms. Graham.
Object, I think it's overly broad.
Ms. Graywall.
I also object.
That's a no. Ms. McNeil.
Object.
Mr. Payne.
Object.
Mr. Ray.
Object.
Mr. Smith.
Object.
And I am going to say no, so that one fails. That moves us to 2-6.001. This is largely, I believe, conforming. It's getting rid of elected or appointed and going with public officials, since we've now defined that term to include all the electeds and appointeds. Are there any other significant changes in this amendment, Mr. Reed?
Yeah, and I apologize, I didn't put this in the description. It does expand it to include employees. This is something we discussed.
Oh.
That we were going to have employees of the city.
Right, so this expands it to all employees. So, Ms. Graham, it is this amendment, 6.01, along with 6.002 and 6.003, where we're going to get into your issue on corruptly. So let's just introduce all three amendments so we know what options, because I think we have
Yep, I understand what you're saying.
a menu here in front of us. So one would expand misuse of position out to all employees, but keep corruptly. Two would expand all employees, remove corruptly, and put knowingly or intentionally. And three would also expand all employees, strike the word corruptly, and add a revised standard of in a manner in which the employee knows or should know with the exercise of reasonable care will result in the benefit to them. So we probably are going to need to pass one of these and not the other two, since they're not, well, I guess there's
Chairman,
some
if I may
combination.
also,
Mr. Reed, please help us.
the broadening it to all employees, that was actually in the draft last month. So that's not new this month. We had that last month, but since it's added language, it's underlined in the amendments as well. But yeah, when I went back and look at the description, we did include that in the draft ordinance. So all we're changing here is the public official, keeping the expansion to all employees, which was last month. And then there are the corruptly, knowingly, and intentionally, and the known or should have known, those three standards.
So what we need to have, I think, Ms. Graham, is a discussion about what standard you want to have. Then once we get a feel for that, we'll know which amendment, and we'll pass one, and the other two will be probably withdrawn. So, Ms. Graham.
Sure. Thank you, Mr. Chair. I have read the documents produced that would explain these different standards and the impact they would have on the ethics ordinances. In my opinion, that it's in the public's best interest to have language that an ordinary citizen could pick up, read, and have some understanding or belief that they understood what the term meant. So in my opinion, of these three options, I would move that we adopt the option that is in 2-6.002, because knowingly or intentionally, to me, and as a lawyer or as a layperson, I have an understanding of what that means. It's plain language. Legally, we're moving away from using words that have to be defined further to have an understanding of what they mean. In my opinion, knowingly or intentionally is clear, understandable, and the people who serve the city of Tallahassee will understand what that means. It's in the city's best interest and the employee's best interest to have it clear, and that's the clearest language.
Okay, I'm not going to take that as a motion just yet, but let's let everybody kind of
Sure.
weigh in that wants to weigh in.
And if others have different opinions, I would like to hear.
Anybody else want to comment? Ms.
I would
McNeil?
just like to say, I think this is one of the suggestions that we had to the city commission originally, and it was turned down. So I definitely would agree with Mrs. Graham saying that knowingly or intentionally needs to be put in place.
Okay. Mr. Payne?
I agree totally with what Ms. Graham said.
Okay.
This is great.
Just a quick question for Mr.
It is difficult because the language is, we're setting a standard here. And I believe that the standard knowingly, intentionally is one that anyone should have an understanding of what that means in their behavior.
Mr. Ray, you look like you're teed up.
No, I agree with Ms. Graham as far as knowing the intentionally. It was included in the last amendment, but the expansion beyond covered individuals, why in this section we're going beyond covered individuals, but everywhere else we speak only of covered individuals?
Actually, we flip back and forth. In some sections, we do covered individuals where it seems to be covered individuals being basically your management and your procurement employees. For instance, things like conflicting employment seems to be more important against that group rather than a city bus driver also having, a side job doing lawn maintenance, for instance. Yeah. So we use covered employees on those things that the ethics violations, it would be more management-type violations, and we used all employees in all the rest of the provisions. So I think we could probably walk through at some point, maybe if we take a break in the middle of this, we can walk through specifically which provisions use covered and which use all. But since this is misuse of position, which is the #1 category of complaints when the State Commission on Ethics categorizes their complaints into broad categories, misuse of position is the #1 category into which the largest number of complaints fall. It seemed, since that's kind of a catch-all, it made some sense to apply it to all employees, if that helps at all. And Mr. Claypool, you look like you've got a thought. I can smell burning.
The standard applies to any act that a public officer or employee somebody in a public capacity could do. It's not like a quid pro quo, anything like this. This is anytime somebody uses their official position or attempts to or uses some property or resource within their official trust, and that could be, any day at any time. So it's really broad in that respect, because it could apply to virtually anything they could do. And so it could be a bus driver who does something like that. It could be somebody in the maintenance shop who takes home the tools and the equipment and somehow doesn't return them. And so at state level, it applied pretty well to everybody at every level.
And that was Mr. Claypool, that was the standard at the state level, knowingly and intentionally?
No, it's corruptly.
It's corruptly.
So one of the arguments for sticking with corruptly is that we have something of a body of law, of ethics law. Chapter 838, which is a criminal violation for misuse of position, got changed in 216 from corruptly to knowingly and intentionally. I think it's and actually, not or, in the criminal law. But
that's what I was going to ask about, just from a semantics perspective. Intentionally, can you intentionally do something without knowingly doing it? So I don't see why we have both in this piece. You have to know that you're doing it if you're intentionally doing it. So,
This is the same standard that they use in Jacksonville. Jacksonville has an incredibly respected ethics code. Again, to me, and I happen to be a lawyer, but corruptly, I think someone could do something knowingly and intentionally and not have it be corruptly, at least from a layperson's standpoint. So to me, knowingly, intentionally covers more potential misuse of position. But I understand the law may be different, so. But there is a reason why the city of Jacksonville uses knowingly and intentionally, and they have a very well-respected, I don't know if it's knowingly and or knowingly or, but they have a very well-respected ethics code across the state of Florida.
Mr. Reed?
Well, Jacksonville does have excellent reputation. I think they actually just use the word intentionally, so I think they do go with what Mr. Smith stated. They kind of mean the same thing. The challenge that I saw is that the definition has it's a compound sentence. So you have the act, you're committing an act, and then you're receiving a benefit. So there are two parts of this action. So you intentionally take the act or fail to take the act. That, I think everybody agrees, should be the standard. But to take that act with the intent that you're going to then get something out of it, the question is, does knowingly and intentionally or just intentionally apply to both elements of this prohibited act, or just the commission or failure of the act? And I think that was where corruptly, which has been somewhat rewritten by the courts, where they have actually kind of lowered the threshold. So I see corruptly as being a lower standard than knowingly and intentionally because of what we have seen from the courts. And I think we have the grand jury report that dealt with the criminal statute, and while the two are related, they are different, but I do feel we have the first DCA, which is our circuit, and then I think the fifth has also adopted the same standard, and it's that wrongful intent definition that we've actually put into our definition section under corruptly. So we do have corruptly in our definition section, which is another amendment. If we decide not to go with corruptly today, we'll want to remove that from the definition section. But just to clarify any issues on what corruptly really means, we apply, and it really is almost a known or should have known standard that what you're doing is improper. So, and that's essentially what the courts have said. So we adopt the language, and we took it right out of the first DCA's opinion and put it into our definition, so there wouldn't be any ambiguity.
I'm looking at, Mr. Chairman, may I speak?
Please.
I'm looking at the Jacksonville Code right now, and you're correct. It does just say intentionally. Yeah, not knowingly and or intentionally.
Okay. I would simply point in the draft ordinance, this is not amendment, in the draft ordinance beginning at line 78 is where we define corruptly. Line 83, we define wrongful intent, and that goes on at some length.
if I could
Please,
chime in.
Mr. Smith.
I like Ms. Graham's point about keeping it simple. So many people will look at this, so many laypersons who may not have a legal background. Once we start getting into cross-referencing corrupt, then you have to go to the subsections, and then you may get into a debate about what is wrongful intent. I would personally like to see the intent aspect removed, just knowingly, because you may not have wrongful intent initially, but if you received a favor or a gift and now you know about it, that's enough to be unethical in my mind. But you don't want individuals to be able to try to find a loophole. And, well, I didn't intend to get this favor. I didn't know it was wrong. So if we just keep it simple with knowingly, you get to the point that we're trying to make. And you cut out the loophole that could be there.
Comments? Ms. Graham.
Well, I think that that's more in line with 2-6.003, would be my opinion, which is the standard that potentially could involve more behaviors, which I'm not against. I mean, I am not against having the highest, most demanding ethics code for our city. But I think that's Mr. Smith, I think that's more, your comments are more supportive of 2-6.003.
Yes.
You realize the first part of the sentence says that you can't improperly use equipment or make decisions, but improperly using equipment or improperly making a decision doesn't become an ethics violation. It's only improperly using the equipment or improperly making the decision and with a result that somehow benefits you. It's the combination of the two things that we have to keep in mind. So I think as long as we understand, as Mr. Reed said, it's a two-part test. Mr. Reed?
And when I numbered these, and Ms. Tamayo pointed out, probably would be important, I kept my first amendment, I made the existing language, which is the corruptly. Then I went to the knowingly, intentionally, then I went to the known or should have known, which is the 6.003. Those aren't in order of burden of proof. I would say that the knowingly, intentionally is going to be our higher burden. That's going to be higher for us to prove that somebody's violated the ethics code. Corruptly is in the middle, and then the known or should have known, the 2-6.003 would be the lower standard, where if we're, it would be easy for us to prove that in front of DOA.
I think the burden of proof aspect that you just outlined, which is a comment that I was going to make a little bit earlier, I think that's something important that we should consider as well, because ultimately, if the point of this ethics board and everything that we recommend is to encompass a larger amount of bad deeds, we want to make a burden of proof much more easy. And while I agree that the knowing intentionally is much more common language to a layperson that isn't necessarily been through the long 3 years of law school that we all might regret a little bit. But I do think that having a lesser burden helps, and I do think that 6.2-6.003 does make it an easy definition for a layperson to understand while decreasing that burden.
And this is,
Oh, I'm sorry. I thought everyone could hear me. All right. I don't know how much everyone wants me to repeat.
it was brilliant. Everything she said was brilliant.
What I was simply saying is that the third one, 2-6.003, the language of it makes it, it's easy for a layperson to understand what that means, but I also think that the decreasing the burden of proof fulfills the needs of this board and the recommendations that we're going to be giving to the city, which is we're trying to encompass the most amount of bad deeds, and having a lesser burden of proof benefits the city in doing that. If we do make it knowing and intentionally, increasing that burden of proof makes it a little bit harder to pursue.
I think as we look at any of them, the one thing we want to guard against is if I'm a city employee and let's say that I misuse my position, whether it's equipment or decision-making, and I do it for whatever reason, but not in expectation of being rewarded. And then somebody comes to me later out of the blue and says, hey, that thing you did, that was great for me here, and gives me something in compensation. We want to make sure that we haven't excluded that behavior, because if I took the action, I knew it was inappropriate, but I wasn't expecting a reward, and I subsequently got the reward. I've met both elements, but because I didn't think I was going to get a reward, I might be able to skate under some interpretation of some of these. That's my only concern, is that whatever we end up with, as long as both elements are there. I took the inappropriate action, I later got a reward. I think it could be hard for the board in some cases to know that the person, when they took the action, expected the reward, even though both things happened. that makes any sense at all. Comments? I think we are somewhere between 2 and 3, or some variation of 2.
Yes.
Ms. Graham?
Well, again, I'm somewhat conflicted because of the interpretation of the word corrupt in case law. But again, I go back to a comment I made earlier, that I believe the case law interpretation is not what a layperson would come to a conclusion reading the word corrupt versus reading the words knowingly or intentionally. So I'm a little bit, I'm not quite sure. I'm leaning towards changing the word corrupt to knowingly or intentionally, simply because I believe at the end of the day, those terms give more direction to those that work with the city of Tallahassee than the term corrupt, because they're not going to the case law to try to figure out what in the world does that word mean. I mean, corrupt seems to imply a higher standard, and I don't understand. I'd have to go back and, Mr. Claypool, Mr. Reed, maybe you could provide me some of the case law, but I think we're going to make this decision tonight, but I still would be good nighttime reading to understand how the case law has developed that would give the term corrupt a lesser burden of proof than the terms knowingly or intentionally.
Okay. Mr.
Go ahead.
Right.
Mr. Claypool?
Let me kind of, if I could focus the direction a little bit. If what you're trying to do in terms of the elements of proof that you need, or what you're trying to prohibit, if you want, what you're looking at is prohibiting the intentional use or attempted use of official position or public resource. Not an accident, not a mistake.
Right.
You know, it's just, I intended to use my position
Right.
in whatever respect
Right.
it is. And with the intent to secure a special benefit, exemption, or privilege that's not available to similarly situated members of the general public, either for yourself or somebody else. So in other words, you intend that you're giving somebody a special benefit that way. So that's another element of intent there, which is either intending or knowing that you did that. And then finally, the last element, I think in all these versions, is basically with the knowledge that your conduct is inconsistent with the proper performance of public duties. You're on notice that you're not supposed to take the equipment home. You're on notice that which everybody should be, that when you get stopped by the cops, you don't say, "Do you know who I am? I'm on the city commission," you know, that kind of stuff. And my experience under the state statute is if the advocate can prove those things, they've got a corrupt violation of this statute. And so if it's said knowingly and intentionally, or knowingly or intentionally at the beginning, as John said, Mr. Reed said earlier, you know, then you've got the question of what does that apply to? Well, it's probably going to be held to apply to all the other elements, but that's really, I kind of think, what people want. They want, you know, the intentional use of position, the intent to get a special benefit for themselves or this other person, and with the understanding that it's wrong. It's wrong, you know, it's wrongful conduct. So there's, I guess I'll be really wishy-washy. You can get there with almost any of these, with almost any of these versions. You're right, corruptly is a lot more verbose. It would be a lot easier to defend in court if it ever came down to that. But because you've got all the state statute and that history in terms of whether it's too vague or anything like that. But I think really, if that's the kind of conduct that you want to prohibit, almost any of these could do that, maybe a little tightening up or something to make sure that everybody knows what's there. But, and so again, corruptly is a very verbose way of kind of encapsulating those concepts. But again, if you've got those elements there, if they're provable, then you've got a violation, I think, of any of these standards.
So we could go with 1, 2, or 3.
But but probably not all of them. although
No,
I
not all.
guess
We have to pick one.
You could probably
One or the
add-
other.
Should I make a motion on
You
one?
could probably add the language in 3 into one of the others, I guess, but then I think we're probably increasing the difficulty for us. A motion or a comment?
Can I
Mr.
make a
Ray.
Motion to adopt 3? I make a motion to adopt 3.
Second.
I have a motion and a second to, to take up number 3 and adopt it. Is there any objection to that?
I think I have an objection, but I don't know if I can articulate why, which is a problem.
If we need time to think about this, we can TP this amendment and come back to it and let your subconscious work on it.
Yes. I just keep going back to what I believe, I guess I have a conflict with what the case law has developed, because in my opinion, number 2 is the clearest of all of them, and less room for error as well, in my opinion. But again, I think I'm not necessarily making an objection, Mr. Chair, so I will be quiet.
Okay, so I think we're on number 3. I'm not going to say I think. We are on number 3. So what this says is, it would strike the word corruptly and say that if you misuse position, or equipment or your decision-making authority, and you do it in a way that you know or should know will result in a special privilege for yourself or others, that you would have committed this violation. Is that an act, Ms. Graywall?
Just to clarify, are you
Into the
taking-
mic, please, ma'am.
I'm sorry.
You're soft
Same
spoken.
problem again. Just to clarify, are you taking out the reasonable care aspect? Because when you just said it, I don't remember you saying
With the exercise.
the reasonable
Oh,
care.
I was just paraphrasing.
Oh, okay. I
It
just
would be
wanted to-
exactly the language that's here. I was
Okay.
just trying to,
Perfect. No
restate.
problem. I just wanted to double check.
so I have a motion and a second. Since I'm not, let's just go ahead and vote on. Ms. Graham, are you okay to go ahead and vote, or do you need time?
Yes, I'm okay.
Okay, Ms. Graham.
Aye.
Ms. Graywall.
I support aye, yes.
Oh, I'm sorry, I slipped into
That's fine. Ms. McNeil.
congressional speak.
Ms. McNeil.
I'm with number 3.
Yes. Mr. Payne.
Aye.
Mr. Ray.
Yes.
Since you made the motion. Mr. Smith.
Yes.
And I'm going to say yes. With that, we are going to, with the concurrence of the group, withdraw 6.001 and 6.002. We're not voting them down. They're going to be withdrawn.
Mr. Chair, this is the language that they use in Palm Beach County, as I understand, correct? Okay, thank you.
Now, we need to do then a technical, since 3 just passed, I believe that we need to take up 6.004, which would remove the definition of corruptly, since we're no longer using that term. Is that correct, Mr. Reed?
Yes, sir.
6.004? So this is a technical amendment to remove what is now the definition of a term that is now unused. So any objection to 6.004? That passes unanimously. 6.005 would have conformed to Amendment 1 if it had passed. We no longer need this amendment, so it is going to be withdrawn since Amendment 1 did not. Amendment 6.001 did not. 6.006 requires covered individuals, which would be that again, your management and procurement type employees, to report actions that they reasonably believe to be violations of the ethics code to the board. And realize when we require reporting to us, we would then be making failure to report an ethics violation. So not only would could the violator be before the board, but anyone who arguably knew about the violation and failed to report it could be before the board. Not anyone, any covered individual, which is a subset of all employees. So, questions? Discussion?
Mr. Chair,
Mr. Payne?
technical thing, I think I'm reading something wrong here on line 7, independent ethics board in the matter prescribed by the board. Should that be manner?
Manner, okay. Mr. Payne offers amendments to Amendment 6.006 on line 7, strike matter and insert manner. Strike 2 T's and insert 2 N's. So the amendment to the amendment. Any objection to that? Without seeing any objection, the amendment to the amendment is adopted. We're back on the main amendment. Any comments? I will tell you, I personally get heartburn thinking about failure to report itself becoming an ethics violation, and the number of people who might know if I'm well, this wouldn't be low-level employees, because it's, again, covered individuals, which would be your Form 1 filers, your procurement employees, and your elected appointed officials. So this wouldn't be, an OPS administrative assistant who is in fear of their job for reporting their boss. It wouldn't be those kinds of folks. But it would mean that there would be other people who might not be terribly high up on the ladder who could be committing a violation. Ms. Meadows-Keefe.
I just wanted to explain to folks, and I do this in every ethics education, that when folks come to report matters to me, I'm not able to determine them to be whistleblowers. So, in effect, I tell them, hey, you can come and share anything you'd like. I'm going to try not to use your name, but if it comes down to it, I have no legal authority to protect your name if someone asks me. So I just want everyone to be aware of that a call to me is not the equivalent of being a whistleblower. There is already a fair amount of confusion about that. So I just want members to think about that as they're discussing.
Thank you. Other comments, questions?
Has there been discussion of whistleblowers?
We have talked generally in the past about the whistleblower statute and
Yes.
when it applies, but it's relatively narrow. It's far narrower than anybody making an ethics complaint or disclosing a potential violation to the board. So under this language, if I went in, if I was a procurement employee and said, hey, I think somebody above me violated the city ethics code, I would not have whistleblower protection.
And you
Under
can
the-
be retaliated against. Arguably, you wouldn't want that to happen, but
I think you'd probably be hiring one of the numerous lawyers in town on an employment lawsuit.
Mr. Chair, could I ask Mr. Reed or Mr. Claypool, I do know that in the Jacksonville Ethics Code, they have a whistleblower ordinance. Have you taken a look at any of that?
We didn't venture
You haven't?
into whether we wanted to expand this board to fall within the whistleblower. I don't know if that would be considered outside our lane, or that may be part of a bigger discussion we have with the city and their HR department to determine, if there is an officer that has been designated as the whistleblower that an employee is to report to. I think we do open up some problems if we start throwing an additional person in, and then what Ms. Meadows-Keefe stated, if an issue wouldn't be, because essentially if you report something to a whistleblower, there has to be a classification of whether you qualify for whistleblower protection. And I think a lot of the issues that fall in here, like accepting a gift, would probably not rise to that level of being determined as a whistleblower, so that person would not get the protections on the whistleblower statute. Does that sound accurate?
Mr. Smith?
and, yeah, it does.
Okay.
I'm not comfortable in a situation where harm or immediate harm would not be an issue, putting the person in this position without any protections. So I wouldn't be in favor
Yeah.
of this type of language.
Mr. Smith, I agree with you, but I do think that we should look into whistleblower language and just consider it in the future. Because it seems to me that that is what this language is supposed to be achieving, but without any protections for the individual that's coming forward.
So we will put, on a future agenda, within the next 2 months, we will put a discussion of the current whistleblower law so we all understand it, because I can tell you I can't cite chapter and verse.
Yeah.
And then we will also consider whether, because we can make, this is not our only chance to make recommendations to the city commission. So we will put a discussion on there if we can craft some kind of ordinance recommendation that would relate to whistleblower in relation to the City Ethics Board and the City of Tallahassee and what we can do by ordinance. We need to figure out whether we can, by ordinance, since we've got a state law, what we'd be carving out some kind of new law here and figure out just how far we can go. But
I
we'll
do
put
know
that on
they've done
agenda.
this in Jacksonville, so there has to be a way to
Way to do
achieve it. We can take a look at that, Mr. Reed, and no need to reinvent the wheel, see what they've done.
Yes.
And then we can have further discussions in future meetings.
Absolutely.
And we'll get that on an agenda, and if we can come up with a recommendation, we'll just make a subsequent recommendation if that meets with your needs, Ms. Graham.
Thank you very much.
And we can get the city policy on whistleblowers and how it's handled now. So you could identify that and any shortcomings you think it has to make recommendations. I also know in our board bylaws, if I receive something that sounds like a whistleblower, I have a reporting process for that.
Okay, so we are, with a brief excursion down a rabbit trail, we are on 2-6.006 as amended. Is there any further discussion or questions?
I object.
Okay, I think there are going to be objections, so yes or no. Ms. Graham?
Object.
No. Ms. Graywall?
I also object.
Ms. McNeil?
No.
Mr. Payne?
I'm in favor.
Yes. Mr. Ray?
Object.
Mr. Smith?
Object.
And I'm a no, so that's a 6-1, and that amendment does not pass. We are on 2-10.001. This is similar in that it creates, again, an affirmative duty for any covered individual to report to the board and the city attorney. This is much narrower than the previous amendment. An affirmative duty on the part of any covered individual, again, your management, procurement employees, to report to this board and to the city attorney any offer that is made to him or her that he or she believes was made to influence a vote, an action, or his or her judgment. So basically, something that would fall short of a bribe, but in that general direction, this creates an affirmative duty when they get something, an offer from an outside, maybe not even an outside person, from anyone. I guess it could be from one of their coworkers or from a city official or whatever. A vendor.
So a common situation I get calls about is there's going to be a training or a conference of some kind, and a vendor wants to provide some kind of promotional material or a course. There's always some confusion when those trips happen about whether the individuals can take those or not. So I just think it would be important to clarify exactly what we're talking about here. Because say a city vendor wants to bring a tray of sandwiches to a fire station. We're concerned about that. So I just think it could be expansive and have unintended consequences, so the board may want to talk through those issues.
One other thing, I believe this is another either-or thing with 10-002. I think that's the same language, but it takes out the ethics officer or ethics board.
Yeah, how 10.001 and, 10.002 is purely a technical amendment to get rid of the term reporting individual. In line 6 where it says him or her, the original language said reporting individual, and we don't have reporting individuals. So that 10.002 is purely technical.
Okay, it doesn't include ethics board on.
Right, we're adding ethics board. My concern in this, again, is creating a new violation, although this is a much narrower thing than any ethics violation. This is, somebody offered something. Personally, and Mr. Reed, tell me, tell me if this sounds, Mr. Claypool, also tell me if this sounds reasonable. What would happen if we added language at the end of 10.001 that said failure to report is not an ethics violation? To make this aspirational, to put the burden on people to tell us about stuff, but to, if they make a bad call about and don't report, to say that they haven't then themselves stepped into the ethics hot box. Well, I'm just offering that as what would for me be comfort language.
Yeah, we could change shall to should.
Or just say failure.
Or we could leave it. Or we could leave it the
Report
way it is.
not
This has been in our current draft. So this one has been one unlike the previous one because it applies to a narrow set of people in a narrow set of circumstances. We have been okay with in the past, but we're digging pretty deep here today.
Mr. Chair, can I ask a question? When an employee would report something of this nature, what would be the next step?
Well, I don't know what the city attorney would do with it. From our perspective, Ms. Meadows-Keefe would go off and talk to the person who was offered, get, any documentation of the offer, and potentially, depending on the nature, if it obviously was a criminal in nature, it might be passed on to the state attorney or the sheriff or the police chief, a variety of actions, but do some preliminary fact-finding, and then bring it back before the board to see what we want to do with it, and/or if it's serious enough, we would go into a non-public meeting and look at it as an ethics violation, treating it as a complaint.
I just have a quick question where it says ethics board and city attorney. Would we have to create our own internal process of how that's done? Like, would it, because that states that both the city attorney and Ms. Keefe would have to talk to one another, correct? I guess my confusion is if they have to report to both, is that, I'm not saying too much of a burden, but just too much of a process? Like, should it be simplified where it's just one or the other, perhaps?
Well, we'd be afraid.
The issue with the city attorney is that they are depending on who's involved, they may have to provide representation to the person who was offered. It could have been a vendor who offered something to a city manager or a city management employee, and the management employee didn't accept it, but the city attorney would be representing the management employee on anything that happened, even though the ethics complaint really shouldn't ding the management employee. So I think the idea here was to provide some fairness that we're not trying to do a gotcha in that kind of a situation. Let them take their own path and we would take our own path, and we wouldn't necessarily talk to each other. Okay. And Ms. Meadows-Keefe, you want to expand on that?
I will expand on it. I'm not sure how helpful it'll be, but I do see that the board is independent. That's something we've made a big point about, and that our process would be independent of that from the city attorney's perspective. So if there was a vendor that was inappropriately trying to influence a particular employee, we could educate about that. So it wouldn't necessarily be a prosecutorial type of situation. It may be something we just warn about, or in an advisory capacity. It's come to our attention that vendors are offering benefits X, Y, and Z. Please be reminded that you shouldn't take those kinds of gifts. So whereas the city attorney may be dealing with that particular vendor and saying, hey, cut it out, our role would be instead educating employees on what to do if they are offered such benefits. I hope that answers the question some.
That does, thank you.
Okay, so this amendment, we have language in the current draft that says that these actions, activities, have to be reported to the city attorney. What this amendment does, correct me if I'm wrong, Mr. Reed, is this adds, you have to report to both the board and the city attorney. That's the primary thing,
correct.
along with making a technical
Yes.
change.
And there wouldn't always be an expectation of cross-communication, right? So
I wouldn't think there would ever
information
be.
sharing may not occur, nor would it maybe even be appropriate.
Right.
Okay.
So, other questions or comments? Is there objection to this amendment? Seeing none, passes unanimously. Everybody's sitting still for, okay, that amendment passes. The next amendment is withdrawn because it did the same thing, just didn't add the ethics board, so we've addressed it. No,
It didn't get added.
no. 13.001. And there are two amendments to this amendment. So the main amendment here, the changes are on page 2 of this amendment, beginning at line 25. It expands it to covered individuals rather than just elected or appointed officials, I think, and then it removes the definition of gift, or it removes a reference to gift as defined in section 112, since we've now defined gift ourselves. Is that an accurate description, Mr. Reed?
Yes.
Okay, so questions, comments on this amendment? So this relates to knowingly soliciting a gift from a vendor or potential vendor, or indirectly accepting.
Are we on the amendment to the amendment?
I'm just describing the main amendment. We're not voting on it yet. Okay, now we go to the first amendment to the amendment. It's 2-13.001A. Mr. Payne.
Yeah, this, again, removes the limited definition of relative here and uses the definition that we adopted earlier
Okay.
for the reasons stated before.
So this takes out immediate family and cross-references our definition in our draft ordinance of relative that we talked about earlier. Is there any objection to 13.001A, the amendment to the main amendment? Okay, without objection, that passes unanimously. Then we're now on the second amendment to the amendment. This is numbered 13.001B. And this is inserting the definition of gift as a cross-reference to Florida statutes. We've had this discussion. Mr. Payne, you would withdraw this amendment?
Yes.
Okay, so that amendment is withdrawn. We are on the main amendment, 13.001, as amended. Questions or comments? Is there any objection to this amendment? Seeing none, that one unanimously passes. We are on 14.001. This removes a bunch of basically extraneous language. It appears to strike sworn complaints. The requirement for sworn complaints is in another provision. So by striking sworn complaint here, we are not removing the requirement for complaints to be sworn. That will come up in a later amendment. So is it fair, Mr. Reed, to describe this as primarily technical, getting rid of surplus language?
Yes, I think by covering covered individuals, we cover all the people that are stricken. And the issue of the sworn complaint, by leaving that language in there, it would not allow any penalties to be assessed on a self-initiated complaint. So I felt that this was too limiting. The issue of whether it be sworn or not sworn will be dealt with at a later amendment. So even though it's being taken out here, it really is not.
Okay, and the majority of the language is the lengthy provision which says violation of the city ethics code, including but not limited to a series of things. It seems unnecessary to list the things that are in the city ethics code since we're in the city ethics code. It's kind of self-referential. Comments, questions? Any objection to 14.001? Without objection, that one passes unanimously. 14.002. We are in the penalties section. This is on corrective action. And you remember the first part of this lines, in the amendment lines 5 to 8, Mr. Smith had recommended that we be more specific with respect to corrective action, so we added restitution. This would go on to give another example of something we could do. There was a recommendation from Citizens for Ethics Reform that a penalty the board could impose would be demotion or termination of an employee. We were concerned that we were moving directly into employment law, and any subsequent lawsuit would involve us as a party, and that the more rational, the less litigious position to put us in would be to make a possibility for us after an ethics complaint would be to make a recommendation to the city that they take some employment action against the individual. So it could be anything. It could be termination. It could be demotion. It could be anything else that is within the disciplinary authority of the city related to that employee. So, any questions or comments on this? This is an expansion of a penalty that we'd be making a recommendation rather than imposing a penalty. Okay, without objection, this one passes unanimously. Still in the penalties section. The next one is where it says that we could have impose a fine up to $1,000 per violation. This would add or up to $1,000 per violation or up to the cumulative value of the financial benefit received by the violator. Mm-hmm. So if somebody took $50,000 in bribes, we could impose a $50,000 fine. And I can tell you when we get to the board bylaws, I am going to recommend that we have a bylaw that says that any financial penalty that this board would impose, with the exception of recapturing our investigative costs, any other financial penalty, when received, would go into the city's coffers. We should not be building our budget through our decision to fine someone. So, but that's a bylaw thing. That does not need to be in the ordinance. That would be our internal process. So this would allow us to recapture that money. In this case, that would all go straight into the city, to the taxpayers' benefit. Mm-hmm. Okay. Any objection to this amendment? Seeing none, this amendment passes unanimously.
I'm sorry.
Ms. Graham.
So the maximum penalty would be the amount of the violation? That would be the maximum? There would be no additional penalty?
Well, remember, we have another provision in the penalty section that requires disgorgement. So let's say that I received $5,000. I could get a $5,000 fine under this provision, and I could be required to disgorge the $5,000 I got. So there's a $10,000 hit to me financially.
Okay.
So it's the cumulative value there that would, as some people have suggested, the penalty ought to be higher. This makes it directly proportional to the financial benefit that I received.
Okay. Thank you for the clarification.
So, any objection to this?
No objection.
Okay. This passes unanimously. 14.004. This was a recommendation from Citizens for Ethics Reform. They did not like the reference to EB1, which is the city's financial disclosure form. And this actually is a good idea because it kind of future-proofs the ordinance. It says that any city official who doesn't file whatever financial disclosures they're required by law or ordinance to file. So we have a new constitutional provision that will be taking effect in the next few years, and there will be changes in state law because of that. So whatever happens, if the legislature changes financial reporting requirements, whatever happens, they have to file those, and if they are late, then this penalty would apply. You got to look at the context, yes. Could be.
My question that I just asked is, would that also allow the board to penalize for late filing of Form 1 in addition to late filing of the city-required form?
Yeah, that's a substantial expansion here. This right now only applies to the 5 elected officials. We have a lot of Form 1 filers, including us. So if we want to keep this more like it is today, we would need to put 4 elected officials back in and not strike those words.
Or covered official, or covered individuals?
Well, covered individuals would pick up all your Form 1 filers,
Okay.
as well as procurement employees. So it would actually be, well, procurement employees aren't necessarily required to file a Form 1 state financial disclosure. So I guess the question here is, we got the future-proofing thing, which I think should not be controversial, but the bigger issue, which I should have really focused on, is this expands it dramatically when it expands from elected officials. So I can say I, for one, would not be opposed to putting 4 elected officials back in, at least for the time being, until we get a handle on this, because we know lots of people, and I think, Mr. Claypool, I would be right on this, that in terms of late filing with, and you may not know the data, with late filing with the state, there's a lot of Form 1 filers who file late because they maybe are not as aware as elected officials.
Well, everybody hopes that notice is in place. They get reminder phone calls even now. So there are some people who do slip through the cracks who are not the elected officials. And they would be subject to the ordinance as amended for the city of Tallahassee.
So what would be the will of the body here?
I see no reason not to have the penalty for all people required to file the form.
Anybody else weigh in?
For everyone who does file that form, if it's covered individuals, everyone is supposed to have gotten adequate notice? Is that the proper procedure?
Yes, you're put on the list. Everybody can go onto the Ethics Commission's website and see who under the city of Tallahassee is obligated to file the Form 1 financial disclosure.
And you do get several reminders to do so. The last supervisor of election actually sent you a registered letter you had to go to the post office and get. So they do a lot of reminding.
I think in a situation, I agree with Mr. Payne, where if everyone is given adequate notice and certainly reminders, I see no reason why they should not essentially be an adult and take responsibility for it as a city employee.
Who polices it?
Well, that was my question. That would be an extra function that we would need to take a look at.
Or if it was reported to us, and we could address that in our bylaws, whether we're proactive or reactive. The thing we could do is put an exception in here for anyone who can show that they did not receive notice. So
I think that would be a very fair way of handling anyone, as Mr. Claypool had said, just slips through the cracks potentially.
Mr. Reed, Mr. Claypool.
I'm sorry.
Could you guys draft an amendment to Amendment 14.004 that would provide an exception for anyone who can show that they did not get notice that their form was due? Or for an initial filer? Because that's been the other, there has been an issue with the city of somebody who picks up a new duty where they, and nobody told them that they're now a Form 1 filer, and it turns out they find out 6 months later, oh, I should have filed a Form 1 because when my coworker retired and I picked up some of their functions, I just was keeping the office going, and all of a sudden I stepped into this. So if we're going to TP this one, they're going to draft us an amendment to the amendment, and we will come back to it. 14.005. In the current ordinance, it says the board can choose to impose no sanctions based on mitigating circumstances, et cetera, et cetera. And it says first-time violations will usually be in this category. There was discussion previously that language, that first-time violations would usually be in this category, seemed inappropriate because a first-time violation could be a horribly severe violation, and that language ought not to apply, and it seems like surplusage.
Yeah.
So, any objection?
No objection.
Without objection, 14.005 is adopted unanimously. 14.006. This is on investigative costs, that we could order payment of our investigative costs, and this would be reimbursement to our funding, up to $1,000 per violation. This would strike the up to $1,000. So if we spent $2,500 on an investigator, we could require the violator to reimburse $2,500 to basically our budget, which comes directly from the city budget, which comes directly from the taxpayers. Yes.
Okay.
Any objection?
No objection.
Without objection, that one's passes unanimously. Amendment 14.007.
Oh, this was mine.
Ms. Graham.
Well, this came out of a discussion that I had with Mr. Reed about a process we had in place at the Leon County School District, just to discourage complaints that that have no substance or merit to them. One second, please. I'd be interested in what the rest of the board thinks about this. I'm happy to withdraw the amendment if there isn't a feeling that this is a worthwhile consideration for the Ethics Board.
I can say personally, I kind of like the idea of getting the concept of spurious complaints in place. I know that courts will order, not for all matters, but in a particular matter, order that a complainant may not file anything else with the clerk on a particular matter because when they begin to file spurious documents. That has been an issue a couple times with sovereign citizens.
Absolutely.
And I think that again, is something we might want to address in our bylaws, that after we see a complaint come in from somebody the second or third time on essentially the same thing, that we say we're not accepting any more complaints on this. But this kind of goes along those lines of recognizing it could be a problem, and because there's going to be a cost to the city, this would provide some compensation back to the city.
Well, again, that was my intent when we initially discussed, and I'm sorry, I have been consumed with my family issues in South Florida for the last 3 weeks. So I do think there is merit in this, and I want to encourage those who have legitimate complaints to come forward, but I also want those that do come forward to understand that this is very serious. I mean, this is not just an opportunity to bring forward a complaint because you have some issue or something that you're concerned about, that unless it has real weight to it and reason to do so. And if this is some way that potentially it might dissuade someone who wished to come forward for not the reason that the board exists, for not the good intent of the board, but for some other reason, then I think it would have a value to it.
And particularly with a board that meets once a month, the filing of the complaint could be newsworthy, and the resolution of the complaint could come a month or 2 months later, and the relation to the original story would have been long lost to most people. And
right.
That's not fair to the person about whom the complaint is made.
And I appreciate Mr. Reed capturing our conversation in this amendment. Thank you.
Any other comments or questions on this amendment? Mr. Reed.
Just to clarify, I think a couple of issues, I did put it in the explanation. This would require a separate hearing, so it's not just the person would have the opportunity to dispute it. And we did this is something we had worked on at our last meeting. We changed it to they have to know what they're saying is false, or they have to show a reckless disregard for the truth. So it is a pretty high
Right.
standard. So,
We don't want to have a chilling effect on those
and that was
coming
exactly
forward.
the point. is
Exactly,
We didn't want to
exactly.
have a chilling effect. So
Right.
we did create a high standard that we would have to prove in
Right.
order to assess these fees against the complainant.
Any other comments or questions? Any objection to the amendment? Seeing none, this amendment passes unanimously.
Mr. Chairman,
Mr. Reed?
if we could maybe go back to 14.004 and get some additional guidance from the board on the late
Please,
filers.
you're recognized.
Two of us, we, and this would just be the preference of the board, whether you would like the reasonable notice issued to be a requirement of proof by the board, or whether it would be an affirmative defense of the late filer. So, for instance, if we were to amend it so, okay, yeah, upon a finding that the individual received reasonable notice of his or her obligation to file, and then that would, yes, so that would be the burden. And then the defense, unless the individual did not receive reasonable notice of his or her obligation to file. So it really is the preference of the board.
I would lean toward affirmative obligation. That they show us that, they allege that they didn't get anything in the mail, maybe they changed, maybe their mailing address changed and they didn't get anything, and then we would go to supervisor of elections, whoever, and they would say, yeah, we got these things in return mail. So there would be some, but they would initiate it. Does that make sense? To anybody?
Is it beneficial to have both provisions be put into place so that we can look at both, just to see what difference that would make?
I think that as a defense, they could always raise as a defense if we have a burden of proof to show that they did receive it. We get notice from the Commission on Ethics or the Supervisor of Elections, whoever's required to send out the notices. We say, oh, we have proof that it was mailed out on this date, and they could always come back and say, well, but you haven't met that burden because I moved and they mailed it to the wrong address.
I think what Ms. Graywell is saying, can you draft both of them?
Oh, so
And make us copies. We're going to take a break here in a few minutes.
Okay.
Make us copies, and we'll look at them, and we'll make a decision with actual words in front of us that aren't projected on internally in our
But
brain
I do a
cells.
better job reading than I do thinking of what the word might look like.
Yeah.
I'm visual as well. That would be nice, thank you.
Okay, so we'll do that. That puts us on 14.008. And after this one, we're going to do one other thing, and then we're going to take a break. But 14.008, this removes sworn complaint. So on line 352 of the draft ordinance, I'm sorry, this is sworn complaints as it relates to the ethics and fraud hotline. The current ordinance says that sworn complaints are not required to report a matter to the ethics and fraud hotline. So these would be, as we well know, the majority of the calls that come into the hotline are not ethics calls. They are things that get referred to law enforcement or to personnel or wherever within the city, or to some other city or some other government, because some of the calls don't relate to the city of Tallahassee. So the question is, do we want to keep this language about the hotline in the ethics ordinance, or does it seem like surplus language?
Is this different, Mr. Chair? This is different than actually filing a complaint. This is an individual who's calling the ethics hotline.
Right, and we'll get to the issue of sworn complaints later.
Yeah.
This one, I got to tell you, this one, it doesn't give me any heartburn being in there, and it doesn't particularly give me great heartburn to take it out,
But if sworn complaints is addressed later, there could be a confusion between. This line.
It leaves it would leave if we take sworn complaint out later, then it would leave sworn complaint in here, which would seem odd. Mr. Reed?
Because I think this was, and I may have made more of an issue out of this than maybe I should have, but the issue that gave me heartburn is, one, I think if somebody were to call, they raise an issue, we see it as a legitimate issue, and we have the ability to self-initiate. So I think there is a remedy if somebody were to call and raise an issue that falls within some of our prohibited acts. The part that I had concern was if we created this exception where the sworn complaint is not required when reporting it to the hotline, then as the complaint moves through the process, is it still that individual's complaint, and they've now lodged an official complaint, just it wasn't required to be sworn if they do it through the phone, or does it move to the board? And that was where I thought if we just took this out and we left it the way it was, then we have the complaints that are put in by writing, whether it's sworn or not sworn, we'll address that later, and then anything through the telephone, we wouldn't call it a complaint, but really it's a tip, and if it's a legitimate tip, there's nothing that prohibits this board from self-initiating a complaint.
Okay, other comments or questions? So I think Mr. Reed makes a compelling case to go ahead and take this language out and avoid any confusion with sworn complaints, because we know the hotline is just something different from the ethics complaint process.
Right.
So without objection, Ms. Graham, I saw a finger
Nope,
go up.
no
Okay.
objection.
Without objection, this amendment passes unanimously. I want to drop back for 1 second to something that I think Ms. McNeil said. I see Mr. Currington in the audience. At the beginning, you said, before we made the decision on board attorney, you said, well, we can consult with either, I think. There are a number of situations. One is we will have a need for prosecutors as we get ethics complaints, where we will need an additional attorney because the board attorney needs to represent us. We will have situations where we may have the board attorney may have a conflict of interest, and we will have situations where there is simply a second opinion needed or additional work that is needed beyond the board attorney. So where I would like to end up, I'm not making a motion here, but what I would like to do before we take our break is plant the seed here that we have both Mr. Currington and Mr. Claypool, we keep them to the extent that they're willing to available to us for either at the will of the board or with some limitations probably, a need identified by the chair to go to them when the situation calls for it. For instance, I think when we get into some of the technical aspects of our bylaws, there will be advantages in having two sets of legal eyes on what we're going to be doing, much as I think there were advantages in, I will tell you, the last several weeks, Mr. Claypool, Mr. Reed, and Ms. Meadows-Keefe and I have spent a lot of hours in closed rooms going through all of this stuff. And it was a very cordial, very collegial process, and it was great when all four of us were smiling. It certainly provided me with a very high comfort level.
Smiling is good.
So if you guys would think about that when we come back, I'd like to finish up that kind of issue as an offshoot to our board attorney discussion, and then we will pick back up with, we'll probably be ready to go on 14.004 and then dive back in at 15.001, and we should be able to finish up, I hope, in about 45 minutes. And with that, we're taking a break till 6:15. Diverted us to the issue of board attorney backup, consulting, on-call kinds of things. Mr. Currington, I have a card from you. Does it relate to this board attorney stuff? It does. Would you, I'd like to recognize you, please.
Mr. Chair and members of the board, I am Jerry Currington. I am not here to address your vote on item 2. You have hired 2 great lawyers, 2 fine lawyers. I understand and respect that decision, and I support that decision. Rather, I am here to introduce myself to the 4 new board members because I debated with myself whether I wanted to go knock on and talk behind closed doors. So I thought this was the way to introduce myself to the other 4 board members. Not without self-interest, though. I did not want my absence from your earlier board meetings to be misunderstood as a lack of interest, as a lack of interest on my part. I am very interested. I had conflicts. I could not attend the prior meetings. To the contrary, I am deeply interested in assisting this board. As you all know, I served this board for 3 years, and it was a privilege for me, and it would be an honor if I could do that again in any capacity. And I'm really here to address that other possible capacity, as Richard referred to, the advocate position. And I know you've all seen my resume, and I would just add this. I would like to be considered as a possible advocate. I have personally advocated before the State Ethics Commission, probably 30 years ago. I hope Phil can remember it. And for 20-some-odd years, I supervised the advocates from the Attorney General's office before the State Ethics Commission. And I not just supervised them, but I advised and consulted them with them on many prosecutions. So I'm intimately informed on the role of the advocate and the issues that arise in the ethical realm. It was my privilege to serve this board in the past. I would welcome any future opportunity. It would be an honor. And I'm here to answer any questions, if you have any questions.
Mr. Currington, I don't have any questions, but would you please relay to Ms. Minnis that I said hello and that I think the world of her. I had the opportunity to work with her when I was working with Leon County School District, and I know of her abilities. So just please tell her that I said hi.
It'd be my pleasure.
Thank you, Mr. Currington.
Thank you very much.
What I am hoping for is a motion, something along the lines of, we've now hired Mr. Reed and with Ms. Tamayo as a backup, and I got to acknowledge that she was involved also in our drafting meeting, so it really wasn't 4 attorneys nodding, it was 5 in most cases. But that a motion something along the lines of Mr. Claypool and Mr. Currington be, to the extent that we can keep them available to the board upon at the direction of the board or at the direction of the chair, whoever that may be, and hopefully in short order it will not be me, for the wide variety of needs that may occur, not just the prosecutor, but conflicts, unique sets of skills, 2 sets of eyes, et cetera, et cetera. So I would much appreciate a motion if you guys are inclined to do that. If not, then we won't.
I so move to name Mr. Claypool and Mr. Currington as potential advocates.
Okay.
Second.
Second. All in favor say aye.
Aye.
Aye. Opposed, no. Okay. We will work out some kind of agreement with the 2 of you, and I think you can both expect to be needed. We are back on Amendment 14.004. We have 2 versions, Ms. Graywall. 14.004 SA, I guess Substitute A, and SB, Substitute B. Mr. Reed or Mr. Claypool, you want to tell us the difference between A and B?
Mr. Chairman, A is putting the burden upon the board to make an affirmative finding that the individual actually received notice of his or her obligation to file before being allowed to add the supplemental fine. And B, to a greater extent anyway, puts the burden on the individual to come forward and claim, assert, and prove that they did not receive reasonable notice of their obligation to file.
Okay, everybody got the distinction? Preferences?
Mr. Chair, I would prefer we put the burden on the individual to come forward and be proactive. If,
So you're...
which is that, but isn't that A, not B? Is A?
That's B.
B, not A.
A would say that...
out of order.
They're out of
We
order?
find out that somebody didn't
Okay,
file.
they're out of order. I'm sorry. So it's B, right?
You like
Yes,
B.
I'm sorry. I assumed A was first.
Oh, this because it's a stapling error.
Yeah, and it's my literal being very
Anybody else?
exhausted, and I apologize to everyone, but I'm doing okay up here.
I-
No, I would say B
Okay.
would be my preference, which is the first one.
The one on the top of the stack.
Yes, exactly.
Anyone else? Mr. Ray? See nodding? Okay, I'm going to say, since this was not originally introduced on a motion from Ms. Graham, second by Mr. Ray, to adopt substitute amendment B to amendment 14.004. So, Ms. Graham, yes or no?
A, aye.
Yes.
B.
We're voting yes or no on B.
All of the above.
IB.
Graywall.
IB.
Yes.
Ms. McNeil?
Yes.
Mr. Payne?
Yes.
Mr. Reed? Ray?
Yes.
Mr. Smith?
Yes.
And I'm going to say yes, so that's unanimous. Amendment A was never considered because it was never introduced. And B has the effect of as substitutes for the original 14.004, so that is adopted. We have,
And I just want to say really quickly, thank you very much for doing that. This makes so much more sense written out. So.
I agree. Aye.
whatever you guys ever need, we will attempt to do, short of pressure washing houses. We had in this
I could
packet
do that,
also.
though, Mr. Chairman. I'm a good pressure washer.
Oh, you just, that's a bad, okay.
No, it's good exercise. too.
I'll be
Works out
calling.
the arms.
I see here, Mr. Reed, board amendment to board amendment 3.003. Before we take this up, can you explain what this is?
No, I don't know who put that in the packet. It shouldn't have been there.
It should not have been there.
Where are
Okay.
we?
Those are staples.
That,
Okay, all
speaking
right.
of surplusage,
Okay.
you all can throw that one away. We are now on 15.001.
Wait a minute,
This-
14 point,
15.
We've done the 14s.
did they adopt?
B, we took B.
That was the amendment to the amendment.
That was a substitute, it was drafted as a substitute, I called it a substitute amendment.
I'm sorry, excuse me.
Okay, so we're on 15.001. This is a technical amendment, gets rid of elected or appointed and uses public, which is consistent with our definitions. Is that all it does, Mr. Reed?
Yes, it doesn't expand the jurisdiction, it simply changes the elected and appointed.
Okay, so this is technical. Any objection? Oh, you're apparently, turn your mic on, please. This is a technical amendment. Any objection? Without objection, this amendment passes unanimously as adopted. 15.002 is a technical amendment replacing may not with shall not, being a little more, I don't know what,
Firm.
antiquated, firm. Any objection to 15.002?
No.
Seeing none, that passes unanimously as adopted. We're on 16.001. This would add a requirement that at least once a year, the Ethics Board must review the outside employment records that are filed with the city by employees of the city. I would note this is something we can do whenever we want on our own initiative. And I personally do not like the idea of having the commission tell us by ordinance to do things that we can, to do things once a year that we can do whenever we please. So I would propose adding this to a future agenda and not suggesting it be done by ordinance. And we just make this part of our normal process. but I would be happy to hear other comments. or
As long as it is added to a later
Okay.
agenda.
Ms. Meadows-Keefe, you are so directed.
I'm sorry, can you please say that again?
I'd like that added to a later agenda. We don't
Okay,
have to include it
perfect.
here.
I couldn't quite hear that. I do know, I think, what the intention is.
Right.
Outside employment forms are reviewed at state agencies, and then there's a potential that your outside employment could be deemed inappropriate. So it actually doesn't involve just reviewing it to see if it's in good order. It's to see if it conflicts with your employment. So I'd just be concerned doing this exactly why we're doing it, if it's not to find a particular fact out, or we're just auditing that people are doing the forms.
It, sounds like an audit to me, which is appropriate, I think.
I think what we will do is we will regularly put this on an agenda at least once a year, and we need to find out exactly what the policy is about how often they have to be filed and when they're filed and such, and we'll put it on agenda at the appropriate place on an ongoing basis. We might add this in our bylaws that we do this, and we'll take a look and just issue spot. And if we find something, then we'll pursue it.
It can also be part of our annual report, like just report that number of people that have filed the form.
So without objection, this amendment fails. Without objection, that amendment fails. 16.002, this is in the provision on conflicting employment and conflicting contractual obligations. We modeled the language in the current draft ordinance on the statutory provisions. There are two of them. We kind of combined them into one thing. There is a subsequent statutory provision that provides some exceptions, and we did not originally pick up those exceptions. So, Mr. Reed, you want to tell us a little bit about what this does in terms of adding those exceptions into our draft?
Sure. There is subsection 12 in 112.313 that provides exceptions only to the doing business with an agency and the conflicting contractual agreements sections of that statute. As I stated earlier, we kind of took those two sections and merged them, but we didn't put exemptions in. I reached out to the chairman. I actually had an issue with a municipal client where we actually had this exact issue where we had to buy real property from our town clerk, which is prohibited under 112.313 subsection 3. So there are situations where exceptions are necessary, and I feel that we need to have those exemptions in place. It's very thoroughly drawn out. It's not really loopholes because there's transparency at every step. And the instance that we had, it was the sole source exemption, which if the person that's not supposed to do business with the agency or the city is the sole source, well then, does that mean you can't do anything? So this just allows us the ability to make an exception if necessary and provides full transparency to this board and the city commission.
Is that an adequate explanation for everyone? Any comments or questions?
Just comment, I believe Mr. Claypool commented on this at the workshop, provided some good examples as where it would kick in. I thought it was good. I appreciated that explanation.
Okay, any objection to this amendment? Seeing none, this amendment passes unanimously as adopted. Amendment 16.003, this strikes about 7 lines that relate to a requirement in the ethics ordinance for outside organizations, or private organizations or vendors to report offers made to influence that they may have seen happen. Again, the ethics ordinance and the charter, or the charter amendment required the city to adopt an ethics ordinance related to employees, and this would relate to people who are not employees, so it seems outside, the language we had drafted seems outside what the charter allows. So this is a proposal to take out that requirement for outside persons who are not city employees or officers to do any reporting. I would note that in our, we do have some recommendations related to the city adding some provisions in contracts that would require contractors through the contract to obligate themselves to ethical behavior, but that's a different matter and a different path to get to private individuals. Any comments or questions on this amendment? Any objection to this amendment? Seeing none, this amendment's adopted unanimously. 16.004 is another changing may not to shall not. Any objection? Seeing none, this amendment is adopted unanimously. 16.005 is a technical amendment. It's got a couple grammatical corrections. I think the original version at the end of line 5 said individual rather than individuals. It's got those kinds of just typographical corrections. There is no substantive change. Any comments or questions? Any objections? Seeing no objection, that amendment's adopted unanimously. That moves us to 22.001. The current language adopted by the city has, and now we're moving into the sworn complaint language, but the first one, while it opens up the section on sworn complaint, which we will come to in a minute, this first one does not address sworn complaints. What it is doing is getting rid of some surplusage where the ordinance tells DOA how basically certain aspects of conducting its business. And we think that the thinking was that DOA has a pretty well-established process and procedure, and we did not need an ordinance to direct DOA how to conduct its internal affairs. Is that a fair description, Mr. Reed?
Yeah, I think this is something we should probably address in our procedures. And I think at our last meeting, we had the 3 sections. The last section were those issues that are more procedural in nature and should be probably dealt with in our bylaws. So I think this is something we don't need in the ordinance. I think it just ties our hands down the road.
Since again, if it goes to DOA, we would be basically sending it to DOA, so the relationship is between us and DOA, not between the city ordinance and DOA. Comments, questions, Mr. Payne?
Is this another choice? It looks like 001, 2, and 3 are addressing the same issues with different options.
They all open up that same section, but this one is a unique issue. So again, if we pass multiple ones, we would combine all of them, so one would not override a previous one. They're not inconsistent. Comments, questions? Any objection? Seeing none, this one passes unanimously. Is adopted. Amendment 22.002. This finally, after having touched on sworn complaints numerous times, is the issue of sworn complaint. It would simply strike the word sworn so that we could simply accept complaints. So they could be anonymous or sworn. We had a fair bit of discussion. Mr. Reed or Mr. Claypool, either one of you want to address this? Please.
Well, the sworn complaint is what's required by state law to get a complaint before the Florida Commission on Ethics. There is some, leeway in terms of what constitutes a sworn complaint. And so the state law takes the position that it can be based on information and belief. Doesn't have to be based strictly on personal knowledge. So you can make a complaint that's based on hearsay, but then hearsay can be public records. It can be a variety of things that would substantiate the basis for the complaint. I think the attorney's fees recourse against the complainant in potential cases is probably the best recourse for getting best complaints out there. But there are people who don't want to put their name on a complaint. And here, unlike the state level, you have a hotline for intake. So there is a mechanism in there for the board to look to try to right wrongs where people might not come forward, but you, of course, have still the responsibility to validate, whatever the complaint is about.
I would add, Mr. Currington gave us a thoughtful opinion a couple of years back that we were concerned about whether or not the board could self-initiate a complaint. So if we got for instance, we got an anonymous complaint, or we just got information from a newspaper article, that was of concern to the board members. He gave us a legal opinion that we have the ability under the charter amendment to self-initiate a complaint. So if we didn't get a sworn complaint, we can basically create one on our own initiative. And it would still meet the test for a sworn complaint. It just wouldn't be a sworn complaint by, for instance, a city employee who might be retaliated against. We would be taking the action on our own. So we could get to a lot of things. Now, so that argues that we can get there with sworn complaint. The counter argument to that is having sworn complaint in the ordinance is perceived as having a chilling effect on people who might report to the board. When they see that, they might not understand that we think that we could take an anonymous complaint and convert it ourselves. They might just see it as a requirement that they sign their name on the dotted line, and they're not anxious to stick out like a sore thumb in their unit in the city, and therefore we never hear about things. So I think that's kind of the pro and con argument that I have heard.
Mr. Chair, I think this could be cured by our consideration of whistleblower language. And I believe strongly that it's important that we do have sworn complaints. As someone who has dealt with, in my time in the school district, I dealt with many complainants that came forward. And in fact, not only did we have sworn complaints, but we notarized them as well, so there was an understanding of the significance. It did not create a chilling effect, in my opinion. In fact, it elevated the process where people felt that, yeah, this is very serious. And the school district was taking it seriously. They took it seriously as well. This is serious. When you bring a complaint forward, I believe that those that you're alleging to have behaved improperly have a right to know. And I think there are other methods, as we pointed out today, that if someone is so concerned that they don't want to bring their name forward, they can call the hotline. We can self-initiate. And I do think we should further evaluate whether we need to have some sort of whistleblower protection.
Okay.
So I would object to this because I believe that we can effectively address the concerns of chilling and other manners by this board.
Okay. Other comments? Questions of our attorneys? Mr.
Question, I'm just not clear. It appears to me that this language directing the administrative judge to action is still in there.
The previous amendment, we've taken it out in the previous amendment.
Right.
So that issue, we've addressed that.
Right.
If we did this, then sworn would come out and that language would come out. They're cumulative. Other questions? Okay, I think this one's just up or down. Ms. Graham, yes or no?
I object. Nay.
You're a no.
No.
Ms. Graywall?
I also object.
That's a no. Ms. McNeil?
No.
Mr. Payne?
No.
Mr. Ray?
No.
Mr. Smith?
Object.
And I'm a no. So that amendment fails. We are on 22.003. I did not see this in the summary, Mr. Reed. So you want to give us this is on relates to our ability to issue or use, maybe not issue, but to use subpoena power. So in the current draft, we have subpoenas only, I think, we've drafted only subpoenas for probable cause.
Yes, for the purposes of probable cause, this is any preliminary investigations. This was actually Mr. Claypool's language. Broadens when we could use the subpoena power, and then we also authorized how the subpoenas would be issued under paragraph 2. So we specify it's police or otherwise provided by law, and that's so it's not very substantive. It just gives us more expansive use of the subpoena and fleshes out paragraph 2.
Right. So this would take what we currently have what we have in the draft is subpoena power for probable cause hearings. This would expand it to any subsequent hearing of the board. So if we go through a series of hearings that we could use subpoenas, and in terms of being served by the city police department, that's consistent with at least 2 other city ordinances for administrative type boards that currently have subpoena power. Comments, questions? Any objection to this amendment? Seeing none, this one is adopted unanimously. Amendment 344001. This is inserting a new section on requiring conduct of that public officials, which would be your elected and appointed officials, must maintain a record of meetings with registered lobbyists at which city business is discussed. This came up in our public hearing. There was some discussion that when lobbyists come into the building, obviously they have to sign the log at the front, so there is already some record being created. But it would not cover, for instance, and I suspect Ms. Graham would be the most familiar with this, the random meeting in a restaurant or a ball game or a dog park where somebody who's a registered lobbyist comes up to you and says, oh, by the way, I have this client who has such and such an interest. This would require keeping a log of all of those conversations.
Well, in a dog park, you only talk about your dogs.
Oh, okay, I'm sorry.
That's the rule. That's the rule of the dog.
Not having a dog, I didn't know about that rule.
So this is very broad. It's not just the meetings in your office. It's anywhere you happen to be.
The meetings in your office, we think, are somewhat documented by the sign-in sheet that people use at the front door of the building. Mm-hmm. Mm-hmm.
I actually don't have a problem with it, quite honestly, because I believe it is inherent upon the public official either to say, now is not the time to have this conversation, shut it down. But I would be interested in what the rest of the board thinks.
Chair, I would have a question if this would address public meetings such as city commission meetings, if people are addressing commissioners, for instance, at that time, do they need to make a note of every conversation?
I would think it would not include those where you're talking about an agended item. If you're taking a break and there's a sidebar in the corner of the room, I think it would cover that.
It would,
okay. I can tell you my personal preference would be to make at some point a policy recommendation to the city that they do a better job of keeping records of it, but not necessarily put it in an ordinance. Because I fear the difficulty of in-hallway conversations, or even if you shut the conversation down, Ms. Graham, if the person's gotten out 3 sentences worth of stuff, is that and you shut them down, is that still a conversation you have to remember to log? Or my recollection in the legislature was that a lobbyist would come in to talk to the Senate president about something. They'd have an hour conversation, and then on the way out, the lobbyist would say, oh, and by the way, I have these 7 other clients, and they have A, B, C, D, E, F, and G issues, and let's get those done too, boss, and then would walk out. And
yeah, might be
how you log all of
overly
those.
Burdensome. It may be overly burdensome.
I don't think the average person would consider that to be a meeting. I mean, if someone is spewing stuff at you, I don't think that's a meeting.
That's a good point. Meeting it could certainly be interpreted to be something that we could read it as much less burdensome than I'm portraying, certainly.
I think meeting would, I mean, I guess if I'm just taking a common approach, it would be that I also have the intent to meet them too, that I'm going to the dog park to meet them, or I'm meeting in the hallway, or I'm giving something back. But if I'm shutting someone down, I think that implies that it's a one-sided thing.
So this is, yeah, I understand what you're saying. Just happening to run into somebody as opposed to setting a time and a place where you're going to meet to discuss specific business.
What would happen if we did an amendment to the amendment that inserted the word scheduled in front of meetings?
I was just about to say that.
Mr. Payne.
Would it be inappropriate to do a high five?
To insert the word scheduled. All in favor of the amendment to the amendment? Say, well, anybody opposed the amendment to the amendment?
I just had a quick question. I mean, I guess the thing is, if you're meeting in the dog park, I guess this is the fine line. So if you're going to the dog park, you take your dog. someone meets you there and they start off spewing, but you thus engage, that's no longer scheduled. But that still is a meeting in which you're engaging with that person. So I guess that writing schedule would take that out, because then you can, I get the feeling that that could create a loophole where you're like, I'm just going to the dog park, and then someone says something to you and you're like, oh, well, it wasn't a meeting, I just went to go to the dog park. So I don't like the idea of scheduled for that reason.
Or what about another hypothetical, if you're at a party together, and you're scheduled to be there, the other person's scheduled to be there as well, and they just take the opportunity to start talking about their lobbying clients to you. What is that? I mean, it is, I think this one will require, I would move that we shelve this and rethink it in the future.
Okay.
Mr. Chairman, there's a question.
Please, you're recognized. Mr. Batzine.
I'm Peter Batzine for the coalition, and I really had promised that I wouldn't get up and speak with you, but I want to draw to your attention the importance of this issue. Jeff Schweers, who's in the back
No, that's
here.
Burlew.
Burlew, I'm sorry, Jeff Burlew, who is in the back, has just had an article that appears on Tallahassee.com regarding the possibility of inappropriate lobbying by people who were not registered to lobby on the issue of fiber optics and overturning a recent vote before the commission. We have no doubt that the list of registered lobbyists is incomplete for Tallahassee, and this is an important issue. And if you defer it, we'll understand that, but we will certainly come back and encourage you to get a handle on this problem, because it's a major one in Tallahassee.
How about if, I see Mr. Payne leaning forward, but how about if we, go ahead.
I just want to point out that the amendment as written is specifically for registered lobbyists. It wouldn't cover unregistered.
How about if we just put on a future agenda within the next couple of months the issue of registered and unregistered lobbyists and maintaining some kind of record of any meaningful discussion of city business with such persons. There's always the issue of a person who is not currently being compensated, so they're not required to register, but they fully expect if this person becomes a vendor for the city that they will be hired subsequently, and so they have every interest. They're not just like a private citizen. They're lobbying in anticipation of becoming a compensated person. There's a whole variety of issues here, I think, that we could look at and then make a recommendation to the city.
Yeah,
We have an in-depth discussion.
additional discussion, because we don't want to shut down just citizen input.
Does that meet with everybody's needs? So with that, I'm going to, is there anybody who objects to voting no or to defeating this amendment with the idea that we'll come back on the issue? Okay, so that amendment's defeated. Amendment 345.001. This does two things. It adds the reporting of lobbying violations to the Ethics Board along with the city clerk. Makes it to the Ethics Board, not the Ethics Officer, by the way. And then on lines 16 to 18, it adds a violation which would be imposed by the city of a lobbying ban for a fourth violation, in addition to the monetary bans for the first, second, and third violations. So those are the two changes. Adds reporting to the City Ethics Board, which would allow us to alert the City Commission or to make various recommendations if we begin to see these kinds of reports coming in, and adds to the 3 financial penalties a suspension from lobbying that could be imposed by the city. Because remember, this section of the code of the ordinances is outside the ethics ordinance. Questions or comments?
I will say that I think that, am I talking loud enough this time? Okay. I don't know if just a suspension for a 3-year period is adequate. I mean, I think that at a certain point when you've made 3 violations, I do think that's quite scary. And I don't know if it's appropriate to do kind of a more permanent ban, but I do think that just having a 3-year period is, I don't think that's enough of a punishment when you've had 3 violations previously. I think 3 violations is pretty substantial.
One of our thoughts there was the practical one, that if you're suspended from lobbying the city, you're going to lose your clients. They're all going to go find new lobbyists. So you basically would have to start over in terms of building your client base. So it has an effect beyond just the 1-year ban.
Okay.
Now, if you want to propose making it stronger or longer?
I think I would, because I do, I mean, I understand lobbying world works pretty fast, and that you would lose those clients, but I don't know if that's, I think that there's a possibility that person the lobbyist would still have clients in other places. I don't know. I just think that that's a little too meek.
So on line 17, it says 1. The last word there is 1. That's 1 year.
Mm-hmm.
So I think you want to increase the 1 to a higher number. Change 1 year to 3 years, or 2 years, or 5 years.
I don't know if keeping 3 years in because everything else has been 3 years. Perhaps make that 3 as well.
Not to exceed. So we have an amendment to the amendment. On lines 17 and 18, strike 1 year and insert 3 years. Any questions or discussion on the amendment to the amendment? Is there objection to the amendment to the amendment? Because again, this is up to, so there's
That's right.
an opportunity for severity or non-severity to come into play.
Right. It's up to 3 years.
So
as the language reads.
no objection. Without objection, the amendment to the amendment passes. That puts us back on the main amendment as amended. Are there comments or questions, further questions or comments on the main amendment? Is there objection to the main amendment? Seeing none, the main amendment, it gets adopted unanimously. It passes. That is the end of the amendments. What I would like is from somebody is a motion to approve the recommended ordinance as amended.
So moved.
Okay, Mr. Ray moves. Ms. McNeil seconds. So on that motion, Ms. Graham, this is yes or no?
Aye.
Yes, yes. Ms. Graywall?
Was it aye or yes? I'm not.
I'm sorry.
Either one.
Yes.
Yes, aye.
You can throw a picture of a thumbs up
Yeah,
at
big
me.
thumbs up.
Lands
2
right.
thumbs up.
Yes, yes, yes.
Mr. Payne?
Yes.
C.
Mr. Ray?
Yes.
Mr. Smith?
Yes.
And I'm a yes. So the ordinance as amended tonight, we will engross those amendments, and we will, that will be forwarded as part of our recommendation to the city. There is no further board action needed on that, other than to the extent that we've put a couple of issues on the agenda for future meetings. We have 2 more things we need to do. We have the annual report in front of us, which includes, which you've seen before, it includes the recommendation of the ordinance and a summary of that. We will make changes to the summary if you will give the Ms. Meadows-Keefe and myself the leeway to make those changes to conform the summary of the draft ordinance to what we've done tonight. And then the other big thing in this is, Ms. Meadows-Keefe, if you would remind us where we are making recommendations to the city for policy changes, that they ought to adopt policy in certain areas beyond what's in this ordinance. And Ms. McNeil moves that we extend the meeting until the conclusion of our business. And Mr. Smith seconds. All in favor say aye. Aye. All opposed nay. So we're extended. Ms. McNeil.
Even though she has to go pretty soon.
Ms. Meadows-Keefe.
But the policy recommendations are, first, starting on page 9, that potentially you would extend a comment period to be a bit longer. We've noticed already that the city has made progress in this. They're considerably more open to comment at different times during meetings. Second was organizational values. I think, again, the commission saw that on our blue sky list and actually impaneled a group of citizens to work on their organizational statement to include ethics. Okay, so these are the ones that we had recommended and we already have seen action. The next several are ones that we're recommending. The first one is voting, and that's that each member of the commission should vote unless they have a conflict, and be present for votes, and if they're not present, indicate how he or she would have voted if they were present. Compensation. This is where we would ask that increases in compensation and benefits of elected officials and the compensation of mayor and commission staffs are prospective only, and we're not going to be retroactive with those. Nepotism, this is actually asking for some proactivity on the part of officials to state any relatives that may have city business. So those names would be identifiable. Fourth, outsourcing. This is something that had been recommended for the ordinance, but now in policy, that if we're actually outsourcing, if the city's outsourcing a key governmental function, that, or the contract is above a certain amount of money, that the ethics code would apply to those folks because they're basically carrying out governmental responsibilities. So the ethics ordinance would apply to them. And finally, with contracts, a provision would be added to city contracts above a specified amount that if a procurement is determined to have been influenced by or attempted to be influenced by an offer made by the entity awarded the contract of a prohibited gift, the contract is voidable. So those are the 5 main policy recommendations as reflected in the letter, Mr. Chair.
And we have done these kind of policy recommendations in the past, for instance, related to airport parking passes, to fraternization policies. It's not unusual for us to do this, and we will continue to do these on an as-needed or as identified basis in the future. Are there any other comments or questions related to this report? Mr. Payne moves that the report be adopted subject to editing by staff and the board chair to conform it to what we have done tonight. Ms. Graham seconds that. All in favor say aye. Aye. Opposed, no. And that is adopted. I would note that we are going to skip the rest of our agenda with the exception of Mr. Batsine. I have an appearance card. Do you have a statement?
I just want to speak on behalf of the coalition. We really appreciate your involvement in this issue. Today culminates over 4 years of work to strengthen the city's ethics code, and we believe that you have risen to the occasion. When over 67% of Tallahassee voters approved this charter amendment a few years ago, we always felt that we could do better at passing a stronger ethics code. We have always encouraged this independent commission or independent board to do so, and I believe that you've done a pretty good job with it. And we appreciate especially your encouraging our input. We were pleased to be part of the workshop. We felt that that was an important collaborative experience. We particularly appreciate those who were able to attend among the board members and also the board council. We felt that we were listened to. We appreciate that. By my count, and I could be wrong, we only lost on 2.5 issues tonight. And I say half. The half was the most important one, which relates to the lobby disclosure. But I recognize that we didn't provide specific language to the board, and we look forward to working with the board. This is not the last pass. This is only the recommendations for this year. We'll have another shot of it each year thereafter. And we look forward to working with you on a tougher lobby disclosure requirement. The only other 2 relate to some enforcement provisions that we think could be beefed up, but again, we'll have an opportunity to bring that to you later. And we appreciate the collaborative nature of our being able to work with you. Thank you.
Thank you. Questions for Mr. Batsine? Seeing none. Mr. Currington, did you have a card? Did you have anything else? I've got you. And Mr. Sims, you are up, sir. Literally up and up. Good to see you up and about, by the way.
Thank you so much. Mr. Heron, I'm here tonight because I believe in this thing called democracy. And I was sitting there in the hospital, and sorry, but I watch y'all on television because I can't get good cable, so I watch you all. But we're on the beginning of a cusp of making some great improvement in local government. And I'm one that believes that local government, ma'am, should work for even individuals like myself. I believe that people are amazed because I know Gwen Graham, and I tell them, you can know her too. This is not a big deal. You know, my mom gets so excited because she think I know folks, because I walk up and I talk to them not because of who they are, but their role in this community. And so now Tallahassee is moving from this thing about, it's no longer, Mr. Hearing, about who's right. It's about what's right. And so people are getting excited. And so I promised my fellow men that I wouldn't hold them long tonight. So what am I driving home? Something is still wrong, Mr. Hearing, when our government is not accessible to our people. I see that we still don't have equal accessibility to government, and it's being camouflaged. And I have a problem with that. We now have a holding section down on the first floor where it bothers me because I put in a complaint to Julie and it's not on the list. So we're up here talking about equality. We're talking about accessibility. I personally came to the Independent Ethics Office and walked Julie from the first floor, the second, the third, and the fourth to show her that the security rules in this building are culturally segregated. I cannot explain. No one yet. I've gone to the commission. I've asked them several times. I've gone to security to ask them to explain to me. Gwen, you've hung out in the Capitol. Why is it that I can go over to the Capitol? I don't have to sign in. I don't have to tell them where I'm going, ma'am. I don't have to tell them who I'm going to see. I don't have to tell them what time I got there and what time I come back out. Why is that? Why is it that when I go to the courthouse, why is that? And then it's not when you get here first come, first serve, they park you. Because if you get there and your person's not ready, you just sit there till they're ready. But if your other next person is there, then you just go on up. That's discrimination working. That's discrimination working. If you just look there, and then what bothers me, I'm sorry, I promised my doctor I would not say get upset. He's an awesome man. I love him to death. Here's what gets me. She knows that this issue is very important to me. Yeah, that's not even on the docket. I've been fighting this issue almost 2 years. So now, ma'am, do I walk away saying, oh, that's just a common mistake? It's not personal, Stanley. It has nothing to do that you lack professional position in the community. It doesn't have anything to do that you don't drive a fancy car, you don't have a big title. That's not that. No, it don't have anything to do with it, Stanley. We just forgot you. How long are you going to continue to forget me? How long? How long will you continue to forget me? See, we're talking these things, but Mr. Richard, I want to live them. I really want to experience them because I see other people getting it. I don't understand, Gwen, and I don't say that in any disrespect. Why are we telling the poorest people over in Southwood, over in the South Side, to go pick up your own paper, tell us where you need sidewalks, tell us where you need, and then we come over here where I live on Buckley, and it's not big now. I ain't talking about Ox Bottom. We don't. I'm talking about Buckley, right behind Buckley Elementary. We don't.
Mr. Sims, into the microphone, please.
We don't spend our vacations a month out of the country. We don't do that. We're over there trying to take our kids to Disney World on a weekend. That's the best we get. And so when you come over there, we got city people telling us, when you got paper on the ground, you call this number, we'll come pick it up. They say you need lights, call this number. We have an engineering department. We've got 2 levels of systems. And I know what Mr. Chairman is going to say. You know what he's going to tell me, ma'am? We have a charter. This is what the charter will allow us to do. But guess what? Guess what this ethic board did when it was so upset about football tickets being given out? It wrote a letter. Even though that man right there told them, this is outside of our jurisdiction. I think that when we have the digital divide that we have, when we have the economic divide that we have the poorest and the employment divide that we have, wages, I'm going to find every opportunity, Mr. Heron, just if I have to wait here from 4 to 7 o'clock to stand on this weak stroke leg to let you all know when you infringe upon my rights, I believe that this board should be just as upset as a man standing up or sitting down in the football thing as we parking people down on the first floor and giving out 2 levels of service in plain sight. Ask them. We've had them on TV. What are y'all doing? Y'all picking up, we're going to show them that we love. No, I told them over in Frenchtown, I'm not picking up no paper, Gwen. I told them I ain't picking up none because you know why I ain't picking up none? Because they don't tell us to pick up none. And I ain't picking up no paper because despite I have sinned and fall short of the glory of God, I'm an ex-felon. I have lost my right to vote, but guess what? I have not lost my right to pay taxes. And when I see paper on Buck Lake Road or on Avondale, ma'am, you know what I do? I call the little people, beautification. Imagine a city employee telling somebody in Southwood or in Ox Bottom, you all need to get together on Saturday and pick up your own paper. Demonstrate to us that you love your community. These are the ethical things that are bothering me. And I'm tired of just getting a listening audience. I'm tired of that. I take it personally. And it's so unfortunate that people like Gwen knows me because I'm embarrassing her. Because guess what? I'm finna get radical for something right. Martin Luther King said, what makes America great is the right to protest for what's right. And I'm asking this board, flex your muscle that you want to have. Question real access. I just had a judge to give me a report, and I hope that you all have read it.
Stanley,
Yes.
you never embarrass me. And what I through the years have tried to do and tried to figure out is how to help you. And I stand today with that goal as well. So why don't you and I talk, not here, but talk, and let's talk about how do we deal with these issues in a productive manner, and if I can help you, I will. And I don't think this is an issue, Stanley. I don't think that this is an issue for this board. And I don't think it's because none of us, I think we care up here, but it's not an appropriate issue for this board, and you're welcome to come and share your concerns, but I would hope that maybe we can channel in a way that will actually result in something positive coming for you. That would be my hope, and I'm happy to work and help you in whatever way I can. Is that fair? Thank you, Stanley.
Thank you, Mr. Sims. Anything else for the good of the order? Any members need anything on the next agenda beyond what we've talked about tonight? Seeing nothing, it is 7:19. We are adjourned.